right, y'all. That means if you're scared, say you're scared now. Okay. All right. Since we have quorum, we're gonna welcome everyone. We will start with roll call. And I'll ask you just to introduce yourselves for the record here in any order.
Harold
Along
Pryor.
on behalf of the NAACP. Go on, I'll yield.
No, I yield to the judge, and ladies first.
Well, thank you. Alona Holmes on behalf of the NAACP.
Hello, everyone. Harold Pryor on behalf of the State Attorney's Office. I'm State Attorney for the 17th Judicial Circuit.
Thank you.
Colonel David Holmes on the Broward County Sheriff's Office.
Hello, Phyllis, DJJ Advisory.
Michael Bell, Community-Based Connections, Community Partner.
Travis Lagon, Department of Juvenile Justice, CAB Coordinator.
Next.
Connie Sanders, DJJ Prevention. Sorry.
Roosevelt Walter Community.
Elijah Williams, Juvenile Court Judge.
Cassandra Evans, Florida Department of Juvenile Justice, Chief Probation Officer.
Brown, Court Administration.
Good afternoon, John James with the Public Defender's Office.
Good afternoon, Dale Holness, Broward County Commissioner, District 9.
Anyone else?
Elder Mathis, Guys Faith Community.
Anyone else? I thought I saw Dr. Osgood on here earlier. Okay. All righty. We want to remind everyone of the norms. Cell phones on silent, please, or vibrate. Raise your hand if you wish to speak. Maximum 3 minutes per person. Respect all opinions and viewpoints, and address other board members and attendees respectfully, please. I'm going to ask if we will allow a slight change in the agenda, because I am going to save Colonel Holmes's life and my own, because he is on vacation. And he needs to give his report, and I don't want to have to go in the witness protection program. So if you will allow the Colonel to move up on the agenda, I'd be greatly appreciative.
Thank you, Madam Chair. Appreciate it.
Okay.
Madam Chair, I will move that the agenda be changed to move up the report of Colonel Holmes on behalf of BSO to go first.
Second.
Been moved and seconded. Is there any unreadiness? Hearing none. All those in favor, let it be known by the sound of aye.
Aye.
Aye. Those against nay, ayes have it. All right, Colonel, you are on, sir.
Good afternoon, Madam Chair and other members of the Juvenile Justice Advisory Board. I am here to give the status report for the Broward County Sheriff's Office in reference to our civil citations. For the month of May, the Sheriff's Office, we had a total of 31 juvenile arrests. Of the 31 arrests, there were 2 civil citations that were issued and 2 that were released to their parents. And I want to go into a little further detail in reference to the 2 that were released to their parents. Those were 2 juveniles that were a part of a group that were involved in grand theft auto, actually grand theft auto with a firearm. The 2 juveniles that were released to their parents just happened to be joyriding with them. They really weren't a part of the felony aspect of the case. And I know that this is something we wanted to hit home with in reference to the program, because there are often where you have innocent young kids that happen to hang around other kids that are up to no good, and their lives can be ruined just like that. The decision was made not to even charge those two juveniles that were released to their parents. So they don't even have any charges pending. So that's one of the things that we're trying to educate our deputies, and hopefully other law enforcement agencies will follow, because we know that there's violent behavior out there, but not all the kids are engaging in that. So if we can save a few, is worth it. So that is the status in reference to those individuals. Right now, we currently in our system, housed at our Paul Ryan facility, we have 8 juveniles, all male, no female. They all are taking classes and are receiving counseling at this time. Throughout our entire system, we have 0, as of last week before I went on vacation, there were 0 COVID positive cases in the whole system, which is good. Things are definitely getting better. One of the areas I wanted to talk about is, I know in past meetings, Madam Chair and board members, we were talking about how law enforcement can better operate and execute the civil citation program. And I know there were suggestions made by Madam Chair and Public Defender Gordon Weeks. And I went back, talked to my staff, and we came up with 3 different levels of ways how we at the Broward County Sheriff's Office can improve the issuance of civil citations. And I'm going to go through each step. One of the steps, and I mentioned this in previous meetings, we improved our juvenile citation log to make sure that our deputies, when they come in contact with a juvenile that possibly may be charged with a crime, that we contact the JAC to see if they're eligible, and to make sure that our guides follow up and do that properly. But of course, human nature, we have individuals that make errors. But to back that up, we want to make sure that they're able to, if they have a missed opportunity and it's discovered down at the JAC, that the JAC can have access into calling that deputy back to come down and issue the civil citation. At the Broward County Sheriff's Office, our deputies have been informed that that's our new protocol, that if they do get a call back, they must go back. If the individual, the juvenile qualifies for the issuance of a civil citation, they must go back. However, as we all know, there are circumstances that may prevent a deputy from returning. And as the 3rd level of the backup, what we are in the process of doing is we will, I think it's come October, when the shift bids go into play and changes go around over in our Department of Detention, excuse me, we will have a cross-certified deputy there at the JAC that will be available to issue the civil citation for all BSO cases. Just in case that deputy can't return for various reasons, it could be exigent circumstances. We don't know. So we currently have 3 levels. Well, we currently have 2, but we will have 3 levels in place to make sure that we eliminate the missed opportunities of issuance of a civil citation. We're going to continue to tweak things. If anyone has any suggestions, ways that you think that we can tweak it even more, please don't hesitate to let us know. And we're also, we just recently forwarded over to the Chiefs of Police Association, Broward County Chiefs of Police Association, a copy of our log and our protocols, so they can see how we're going to be doing it from here on out. And hopefully they can get on board and change that way, and we can eliminate the missed opportunities, because it's not good when you hear that around the state of Florida we're near the bottom. So that bothers me, and it should bother all the other agencies in Broward County, so we can improve that. Are there any specific questions that anyone may have as far as the Broward County Sheriff's Office and our protocols?
I do.
Yes.
I do. So you said there were 31. And
Yes.
on the 27, were any of those misdemeanors?
No, those are all felonies. What's ironic, and I don't know what is going on in society right now, but there are tons of grand theft autos. I don't know what it is, but these kids are getting involved in stealing these cars and getting in chases. And the one case, we had 6 juveniles involved in one case. And 2 of those kids were the ones that were released. They were joyriding, but the other ones were involved in more extensive things before they picked them up. And a firearm was found in the vehicle too. So those are situations that can be very, very dangerous. We all know and saw what took place down in Dade County with that mass shooting. That involved individuals that stole a vehicle and had high-powered weapons. So that's an area of concern for us. And we got to work with the juveniles and making sure that they understand that that's unacceptable to be out here stealing cars and to be out here stealing cars, definitely with weapons in them. And that is unacceptable. So we have to do a better job educating our youth and making sure they stay on the right path as far as that's concerned.
And Colonel, let me ask, so what are the consequences, if any, for a deputy that does not follow your policy? He takes puts the child in the back of the police car, takes them for the ride, and gets there, and it is determined that the child is eligible because he or she did not do their due diligence to determine that the child should not have been taken into custody and taken over there.
Okay, we're fully aware that sometimes errors are made, even though the intentions may be a little different. However, the first offense, we are going to be issuing written counseling. And we're going to follow progressive discipline from there on, all the way up the ladder. This is coming from the sheriff from the top, that it is unacceptable for any of our employees to ignore our protocol. We put a lot of work and effort into improving things, and we don't want to put egg on our face by having any of our deputies, our employees that are not following our protocol. So they will be disciplined. I can assure you that.
Okay. Thank you. Ms. Evans.
Thank you, Madam Chair. So Colonel Holmes, going back to the jail piece of it, it's my understanding that the jail virtual visits will be coming to its conclusion during the pandemic. Could you speak a little bit on that for us as far as going back to do in-person visits? What is that looking like for you all?
I'm going to be honest with you. I can't give you any specific details. Colonel Benjamin over in DOD handles that aspect of it. Okay. I know during one of our past staff meetings, she did state that things were going to be changing due to the, I guess, the changes with the pandemic. Okay. I can make sure that I can get you in contact with her to get the specific information for them.
All right, perfect. I'd appreciate that. Thank you.
Okay.
Okay. We have Commissioner Holness and then Judge Williams, please.
Colonel Holmes, how are we doing in our interface with the other agencies in terms of getting them on board, utilizing the protocols that you're now putting in place? Are they responsive?
So far,
already signed on.
So far, I'm sure the state's attorney office can probably speak further on that. Right now, they're open to receiving our protocols and our logs and to see how we're doing it. They appear to be open to making changes, but we know how that can be. We'll see. We'll see how that goes. But right now, they're saying that they're interested.
Is there any particular city that's already fully embracing and doing what needs to be done?
I think the state attorney will address that when we get to him. This is what we had asked Colonel Holmes was let's start with BSO because they have control over their agency and we'll work toward others. But less than the largest agency and obviously with the largest territory, they have the highest numbers. Let's get an internal process in to deal with BSO and then we could build from there.
Right,
Any
thank
other
you.
questions? Judge Holmes? I'm sorry, Judge Williams?
Yes.
Judge Williams?
Yes, Colonel, a quick question.
Yes.
I'm watching the whole Capitol thing last night about what happened at the Capitol. And what we're finding out is that they had the greatest operational plans, but there was no training. In other words, they had great equipment. They spent millions of dollars on hand grenades and stuff, but only 8% of the troops were trained in how to even operate the equipment. Here is my concern. I met with approximately 56 deputies over the last 5 weeks, not your deputies, but police officers from like 16 different agencies, including the police chief last night. The one thing that they're missing is that grassroots training. Like, who's going to tell the deputy when to issue the civil citation and when not to? There's a million questions that they all have. For example, if it's a chase, and I had 8 cars today, a guy stole 8 cars in front of me today, allegedly. If there's a chase, he's a passenger, it's a trespass. It might be a missed opportunity, but they've used a helicopter and dogs to trace that individual down. They're not just going to issue him a civil citation and say, go home after we've chased you with helicopters and dogs. So who does the training which answers the deputies' questions on a grassroots level as to what do I do? And that's what's throwing me off, because like the Capitol, you had a great operational plan, but only 6% of your troops were even trained on how to utilize the operational plan.
Yes, Your Honor, I could tell you this. We've had training. All our deputies are trained on arrest procedures. We've had training updates on our Power DMS system where we've addressed the new protocols, and each deputy is required to go on and complete the training online. So for any of our deputies to say that they weren't informed on our new protocols, we'll have documentation right there to show whether or not they completed it. It's very, very important, and we stress this with our troops. If they have any questions, if they're uncertain about how to handle a particular situation, there's always a supervisor that they can go through, and can rest assured that the supervisor will and should know the exact protocols. And if they don't, then there's going to be an issue, a higher issue up the chain of command. As we speak, all of us supervisors have been updated on the new protocol, so there should be no reason why any of our deputies, our troops, do not follow it to the T. And if they do, like I stated to Madam Chair, there will, not should, there will be consequences for them to pay, and that end.
Thank you, Colonel.
And I'm interesting you use that example, Judge, because I was speaking to Fort Lauderdale, their interim chief and a major, and what they said was, well, here's the problem that we have with, that some of our police officers have with civil citations. I said, okay. He said that if they have 4 youth in a car, they get to catch the guys, so they've got 4 kids. In addition to the 4 probable cause affidavits, they now have to write a civil citation. Well, first of all, wrong, because the kid who's driving ain't gonna be charged with no misdemeanor. And second of all, it's 1 sheet, mostly check off the boxes. And so so that is what the cops wanted, because I don't know when that case is going to get to, if a kid is going to, if they don't successfully complete, something happens, they're not able to participate, something happens, are we going to know if you don't write the PC? Because they said, well, we should just be able to do the civil citation. Sure. But if we don't write the PC, then we're going to go back to the cop 3 weeks later, a month later, to say, y'all tell us what really happened. So this was an agreement between law enforcement, state attorney's office, and our stakeholders on how we would do this piece. So you have people with excuses all the time. And obviously from this major has no clue that civil citation has nothing to do with felonies. So you get stuff, and it's going to be agency from agency. That's why, you know, I appreciate Colonel Holmes talking about it's going to start from the top, and they're going to make sure that their staff follows their criteria and their policies and procedures. You can get excuses all day, but
All right.
it depends on what cop is going to show up there at the scene.
Correct.
Mhm.
Correct.
Madam Chair,
Yes, Mr. Walters, go right ahead.
question for Colonel Holmes. Colonel Holmes, is there a way that we can find out the demographics of the 31 that was arrested?
Yes, I have that information. I can get it to you. Actually, if you can email me, I'll make sure I get that information to you. I'll forward it to you as soon as possible.
Yes, but I don't want it just to me. I want it to the entire board, because it's important to all of us to know who is being arrested and who is being released. And I appreciate it. If you got to wait, you come off vacation, that's good.
If you give me a minute or so, I can pull it up. I'm technically challenged, but I'm trying my best because I have my phone here nearby. I'm on my iPad too.
Let the record show, and particularly to your wife, that I'm not asking you for this, that it is that's Roosevelt Walters, Walters. I understand that you're on vacation, Colonel.
It's ironic because I looked that information up and I had it, but of course, because I'm on vacation, I don't have the printout. So I have to pull it up right now, but I can get it.
Put Judge Holmes in the meantime while you do that. Judge?
Okay.
Yes, Madam Chair.
Did you have a question regarding the procedure for BSO so far?
No, I'm just listening. I'm taking notes. I'm absorbing. So if they violate, I'm reminding them of the notes that I took.
That's right.
And
hold us accountable.
Ms. Evans, so that works with your staff and what you have in place as well for kids arriving at the JAC who are civil citation eligible. You're working on a procedure, or you do already have a procedure? Is there still a thing about whether they go into Sally Port or what door? Like, how does that work?
We're working through that now. It will look pretty much the way it looks now. We're working on where the young person will sit once they arrive at the Juvenile Assessment Center and they've been identified as civil citation eligible and will be receiving it. Their seating will be segregated. I don't say segregated, but separated from where the other young people sit who are there for higher level offenses. So hope to have that. We're doing our site visit tomorrow and want to get some input from the committee. So once we complete that, I hope to have that done within another week or so thereafter.
Okay, thank you. Any other questions for Colonel Holmes before we, while he looks for that piece? Okay, and while he does that, let's talk about, now let's make sure we're clear on this two thing. There is the state attorney's MOU, or his policy on arresting the 12 and under. And there's separately, there is the civil citation policy. So let's not, I've been hearing conversations where they've been, interchangeable, they've been together. They're two separate things. So I want to hear from the state attorney on where we are on the policy for arresting children or 12 and under, the agencies that are signed on, the ones have not, where we at on just address State Attorney Pryor, just that agreement there.
Yeah, so we'll start. Thank you, Madam Chair. We'll start with the policy of arresting you 12 years of age and younger. As you know, the Broward Sheriff's Department signed on to that immediately, and then we presented that to the Broward County Chiefs. After we made that presentation to the Broward County Chiefs, you are correct. There was kind of a muddling of the issues there, where they were kind of confusing the two issues. Where we were talking about any arrest for children 12 years of age or younger, you to call our office and advise us so we can let you know, don't arrest that child. If it's not one of those offenses that we're going to arrest for, find the parent, send that child home, don't arrest them, don't take them through that traumatic process of transporting them to the JAC. What we noticed with the chiefs and what they brought up was in conjunction with the civil citation program. And so those issues were kind of confused. We really got them to understand that those are two separate issues, but also I saw value in us addressing those issues in an MOU. There was actually discussions with the sheriff's department where we actually was considering extending it to 17 years of age and younger. But then we saw that that would have been logistically, it just wouldn't have made sense logistically. So we're still at 12 years of age and younger, and now we're adding a component. We're actually adding two components. So it's the paragraph where we're also addressing the civil citation program, where we're telling them that if you do encounter a child that is eligible for a civil citation, to issue the civil citation, but also we're extending it to the point of, if in fact you have a child that is 12 years of age or younger for any offense, you're to call our office and seek our advisement on that issue before you take the trip. So we're essentially killing two birds with one stone. That's one issue. We actually got buy-in from some of the departments that that have traditionally been on those missed opportunities reports. I've had 2 meetings with the chief of police for Coconut Creek, and I met with the city manager and certain commission members. And so we now got them on board, and we met with Coral Springs, which was another city that wasn't traditionally issuing civil citations. So those were the 2 major agencies, and I spoke to Davie and Plantation as well, and we actually got them on board. So that's the first issue. That's the first component. So we're still moving forward with the MOU for 12 years of age or younger, and it seems that we're going to get all of the agencies to sign on to that. But we just made one edit where we also added the civil citation component to it. Next, we're also getting.
Hang on. Let me just be clear. So the 12-year-old arrest MOU. Who other than BSO has signed on? Not gonna sign, not agree in principle, but who has put their name on the agreement?
Right now, we just have BSO and DJJ and Coral Springs signed it, but then there was one edit. There's one edit. So really just BSO and DJJ, and we had Coral Springs sign on, but then all of the Broward County chiefs, the attorneys for the Broward County chiefs, they said, let's go back and let's have one document where everyone can just sign at once. So honestly, it's only state attorney's office right now, BSO and DJJ with the current document that we have that has not been edited. The first document that was presented for signature.
Okay, I'm confused. So why would not each individual chief sign off for his own organization, since that's the only one that he can do? Why would it need to be all? I don't get that.
Well, so here's the problem, and I think logistically, if you're in law enforcement, and I know Mr. Holmes Colonel Holmes can kind of back me on this in the sense of, we would literally have 17 or 31 different MOUs out there regarding the rest of you 12 years of age or younger. There were some agencies that didn't want to sign on, but then after meeting with them and speaking with them about the issue, they actually agreed. And so to make things work logistically without meeting with everyone and then coming up with their own edits, and us having 17 or ever more documents that we're going to have, or different documents, it would make sense that we present one document to the Broward County chiefs that has a signature from the Broward County Sheriff's Office and all of the agencies that are part of the Broward County chiefs. So logistically, it makes sense because we have one working livable document to actually work from.
I wasn't aware that you were going to allow them. That policy was written by you. And I thought when you wrote the policy, the state attorney says, this is our policy, this is what we're going to do. So I don't understand how the agencies can edit your document. If you're saying this is what we're doing.
Well, there's a difference. So when we did that, it was drafted as an MOU, as a memorandum of understanding to the sheriff's department, and the sheriff's department signed off on it. Well, you have other agencies that we want to implement and actually add this to their standard operating procedures. And so it's one thing for me as a state attorney to do a directive. They're going to follow, they can follow it, and I can threaten to threatening them to follow it, but they're necessarily not going to have to follow it. They're not going to follow it. And so I think it's better for us to get them to sign on and to get buy-in in order for it to be implemented. So I understand the power of actually initiating a policy, but when you have an individual agency that has their own discretion when they're on the ground and they're dealing with these issues on a day-to-day basis, I think it's effective for us to get all of them to sign on. And it seems that we're going to get all of them to sign on. So, I'm fine with directing a policy, but if I do a policy, they're going to ignore it. Classic example, civil citations that we've been doing for how many years, and we're still talking about the issue however many years later. And so I'm trying to get everyone to buy in on this, and it looks like we're getting buy-in. I think Colonel Holmes can tell you he's noticed a difference in the sense that many of the agencies who haven't been willing to entertain the conversation, they've been entertaining the conversation, and even their attorneys are advising them that you need to sign on to this. So I think it's working in that regard rather than me just issuing a policy and them not following it and choosing to ignore it.
Maybe I was having a different conversation because I was talking to the judge, and she was sharing that if the state attorney made a policy, then that was policy. So if you have an agency who showed up at Jack and with the kid who was eligible, then we were going to work through those different pieces. We've been dealing with the chief of police for many years, and because only a chief can only make a decision for his own agency. Having the chief sign as a body means absolutely nothing. And so we worked through each one of the different agencies individually. So each one of them had their own agreement because they're never going to agree. We learned something called, for the lack of a nice word, I'm going to say professional jealousy. We learned that with Promise, that we started with the two largest agencies, and they were pissed that we didn't start with them. And they're in Mayberry with 10 cops. And so we wanted to be able to get through the largest part of it. But Springs feels some sort of way about BSO, and it feels some way about Fort Lauderdale. And so people wanted to have their own individual piece. And I'll have to go back to the judge, and we'll have to rethink this. I thought that when you made the policy, then people would be signing off on it. I know that the other one was specifically for BSO, but I thought there would be individual agreements for the agency, not on what they wanted to do. And I thought that we were going to keep civil citation separate, because when they merge the two, then you have, it gets messy. So I thought we were going to keep the two.
No, and I agree. And we're still we're still drafting. In fact, they're reviewing. We're actually getting them to sign on to one MOU following our civil citation program, which is a separate issue. But I felt logistically, if you're a law enforcement officer, many law enforcement officers, sometimes they only follow their standard operating procedures or their manual, right? And so if they see one manual and they see a child that may be 12 years of age or younger, or they just see a child that's eligible for a civil citation, they may ignore the civil citation aspect and then forget to actually issue the civil citation or properly report the missed opportunity in that particular situation. And so I don't think it hurts us to address all of these issues in whatever documents we deal with when we're dealing with juveniles that are actually eligible for these civil citations. So I understand that the issues could be muddled, and they were muddled up, but also I saw an opportunity with this policy for the arrest or the detention of children 12 years of age or younger to also address that issue. So when in fact an officer do come in contact with the child, it's almost like a double whammy. It's also serving as a screening situation to actually reconfirm the policies that we're developing now. And so I think there's some added value to it. And I think it's only going to help us rather than hurt us.
Then I'll have to go back to my notes, because we know that all the law enforcement agencies' policies on civil citation were not up to statute. They were outdated. So we were supposed to get those in statute. They were going to bring up, which is a separate piece. But this is the low-hanging fruit where we talked about 12-year-olds, and that was going to be a separate policy. They were going to have Certainly, first, see if the child qualifies for a civil citation. And then second, if they don't, then you go into this whole piece. I must be missing something, but we'll go on to Judge Holmes.
My concern with what Mr. Pryor wants to do muddles and confuses. The average law enforcement officer, all they're going to see is 12 and under. They're going to think it's civil citation. And so the 15, 16, and 17-year-olds don't get citations. They get arrested. When you combine two things that really don't go together, that's a problem. I don't care if they sign off or not on your 12 years of age or under. You're the state attorney. You give them a memo. From henceforth, now and forevermore, as long as I'm in office, before you arrest a 12-year-old, call these people in my office. Period. Into that. Then we're on to civil citation. Let me see your program pursuant to 985-12-5C. If I agree with it, if it comports with statute, you can keep it. If not, you sign on to mine. I don't know why 123 days later, we're still talking the same stuff. So I'm going to be silent because the rules say address each other respectfully. I yield. Thank you.
Okay. Any other questions? I'm thoroughly disappointed. I'm going to say that, but it just could be me. This is not where I thought we were going to be on something that would be, you make the policy, they agree with it, or they don't, or they say, but to say they get to edit your policy and decide what they're going to do and they're reconnect it to civil citation, that's not what we talked about. But okay, so with doing that, with that compromise, you only have SO, which signed on day one, and Springs with the 12 and under. So the rest of them, while you're trying to convince them, they're just gonna do what? They're just gonna show up at the Jack?
Well, Madam Chairman, we would have been in the same situation if I issued a policy with how we know how they operate before I was in office and well after I was in office. So, I mean, we would be in the same position that we were in. How many policies do we have out there that have been out there that we think that work well for our community, that law enforcement agencies or independent agencies or entities outright ignore? And so I think, my opinion, and look, I could be naive for thinking that, my opinion, if you sit down with these people, you get them in the room, you meet with them individually, and you get them to sign on and to buy in, that's better policy. And so that's the way that I'm going. And I think that's the best way to go in this. And if I'm wrong, prove me I'm wrong. And you could say I told you so. But that's the way that I'm choosing to go as the elected state attorney in Broward County. And I think it's the best way to go. And I think it's going to work.
Well, I understand that you are the state attorney, Mr. Pryor. And I'm saying to you, as when we had our previous state attorney, these same cops, and I said this to Fort Lauderdale, I know that you all called Maria on these issues of these babies before you went there. So the only thing that's changed is the administration, that you have somebody else in charge. Now there's a different administration. Now you have an issue with that. But, you know, if you're saying one thing and we're saying another, that's counterproductive and it's not what we agreed to. But you are the state attorney. I understand that.
And you have to understand that policy wasn't written and all of them didn't even comply with it. And so I'm trying to have a written policy where I get them signing on, pen to paper, the agencies are signed on, and it's better to hold them and it's easier for us to hold them accountable rather than me just having a directive or a policy out there that no one is signed on and they can just outright ignore.
Civil citation. Can you walk us through the agreement? Have you gotten all the different pieces? Is the chief judge completed and signed the directive there, and where is Madam Clerk on this, Mr. State Attorney?
Yes, so we signed off. I signed the MOU and I signed the civil citation program. The edits for the administrative order that Judge Tudor will sign has been submitted. His chief counsel or general counsel submitted to us for review and comment. I made my comments. I believe the clerk's attorney made comments. It was sent back to them, and then they sent us a finalized version that they say that Chief Judge Tudor would be prepared to sign yesterday I got word from Allison Shirley Davis, the attorney for the clerk, that there was one issue that the chief judge wanted to address with the AO. And once he addressed that issue, he was going to sign it. So pretty much the only thing that we're waiting for the circuit civil citation program is just for the chief judge to sign off. So once again, the civil citation program, the actual document that we all agreed to, has been signed off on me. It's in possession with the clerk's office, and then she's waiting until the chief judge sends over his administrative order, and then she's going to sign the MOU between my office and the clerk's office, setting up our screening process. So I hope we can get that signed by the chief judge before the end of the week. But I did get a finalized version of that from his general counsel. But apparently there was one final issue that he wanted to look up or he wanted to address before he actually signed the AO.
Okay, to the chair of our subcommittee on this piece, Judge, have you seen the document? Do we know if I know you had some concerns of the previous order. Does it have all the pieces now?
The lighting is better than this way.
I think Gordon is the chair of the subcommittee. I'm just a representative from the NAACP on the subcommittee. However, I've been waiting since I think April 30th, when I kept getting assurances that the chief judge was going to get it and it was going to be signed by Friday. That was April 30th. Here we are on June, what day is today? June 9th. I haven't seen any signed copies. There's no reason for the chief judge to sign off on a memorandum of understanding with the clerk in the state attorney's office. His binding agreement is the administrative order. I've not seen the administrative order. Matter of fact, I told Mr. Pryor that the administrative order that was submitted, that Judge Tudor, I knew he wasn't going to sign it as is, but he didn't ask for any more input from me, so I didn't offer. So I'm still waiting to see the finished product so I can advise the NAACP.
Is the fourth draft, is that the final draft, or is that have there been other edits to it, the state attorney Pryor?
There have been no other edits from our standpoint. The only edit was when the subcommittee met, which was the last time, and that was the final version. So once again, like I said, I signed the final version. I followed the protocol of actually signing it, and then I sent it over to the clerk's office for their signature. And now we're waiting for the clerk's office signature, and then the signature to the MOU as well. The clerk's office, their justification or their stance on not signing the MOU that I signed was based on the fact that you have an administrative order for which that MOU was drafted. And so it's an important or significant part of the MOU. And so they feel they're not going to sign off on it until the judge signs off on this administrative order.
2 o'clock on Friday.
So long story short, state attorney's office is signed off, and all the documents for signature are now in the custody of the clerk's office.
And did you say the chief judge, Judge Tudor, had or had not signed?
The chief judge has not signed the administrative order. They went through a round of edits where the chief judge and his general counsel looked at it, and there's one final issue that they're working out with the clerk's office regarding the administrative order where they're trying to confirm something. And so that's the holdup. And so apparently once the chief judge signs the AO, the clerk's office has communicated to me that they'll then sign the MOU and they'll sign the final version of our circuit civil program. And then they're going to send it over to Mr. Weeks, who's the next signatory for the civil citation program.
Does anyone from the, from the public defender's office have any input? Any thoughts on what the process, where we are?
We have not received anything beyond what we have right now. That's the document that we sent on when it was finished to forward to State Attorney Harold Pryor. And from there, we have not received anything as of today.
Have you all seen either of the two, the piece that was reported, that was submitted to the clerk, or the document that was submitted, or the administrative order from the judge? Anything? All you have is the part that.
No,
Madam Chair, we saw drafts.
Right, we have the draft.
We have drafts of the civil citation program We have a draft of the MOU. We have a draft of the proposed administrative order. We've not seen any edits or any changes, nothing. So I don't know how they're going to sign it and send it unless the subcommittee sees it first to see if, if it's lines up. So we're just waiting to see what comes out before, and it really should come to us before they sign off on it.
Well, he has just shared that he is the elected state attorney, reminded us. So I guess.
Well, I understand that, but we've been waiting 123 days, so I thought maybe we could help them get some signatures.
No, wait a minute. I thought the process was when we agreed to that final version, because Mr. Weeks sent it to me, he sent it to me for signature. And once I sign it, we then send it over to the clerk's office. Actually, it's couriered over to the clerk's office. They have it in the folder, and then they sign it. Then they walk it over to the public defender's office. That's what happened with the first version.
And remember what the problem, Mr. Pryor, with the first version is you all signed off on everything, gave it to us. And I told you, there's nothing in here that documents what the clerk's office should be doing. So that's why she readily signed off on it. There was nothing to bind her. So if you let the subcommittee see before you issue a final product, you won't have to keep sending and have draft 4, draft 5, and we have all these MOUs. That's the way committee work is done. If you have a final version, before you sign it, you can send us copies and say, I'm about to sign this tomorrow. If I don't hear from you by noon, then I'm signing off on it. And at least give us an opportunity to be heard. And I haven't heard anything about Mr. Weeks's office agreeing to the administrative order. In the past, it's always been the public defender office, the state attorney's office, and the chief judge. That's the way they used to do it. But you are the elected state attorney. I understand that. However, you got a lot of shareholders, stakeholders, and sometimes it's good to get different opinions before you have to go and redraft and draft and have second amended drafts and all that stuff. Because even in the MOU with the clerk, you have first amended draft. So that's it tells me in the future you're going to have more. But I understand your position, sir. I really do.
I think we all are clear on that you are the elected state attorney. So I guess this is moved into your wheelhouse, since the process that we decided that we all agreed upon was what we're going to do. It's that you're doing something different. Okay, I see, because you're the elected state attorney. I see.
So the email from Mr. Weeks, that was not the finalized version that the subcommittee had agreed on. That was ready for signature.
Harold, I think the issue is that you indicated when you were speaking that the judge he made edits and then the clerk made edits. If they made edits to what we sent out was the final agreement, then we at least have the opportunity to see it as well. If they have not made edits to that agreement, then we're okay. But what your statement was that there were edits. So if you can send us what the edits are, so that way we can all sign off on them, we can agree on them, I think we will be in a better position.
Understood. So I'll send over the administrative order, the last draft of the administrative order.
Thank you. And just so we're clear, they haven't made any edits to the juvenile civil citation policies and procedures that we all put together and drafted as a committee. I think the last one that was sent out was May 21st. That's the understanding, correct?
That is correct. The only edits that have been made was the edit to the administrative order.
Okay.
And that was coming from the chief judge's office.
No problem.
Were there no edits made to the clerk's portion of it, since the judge said that didn't bind her to do anything?
The only edit made to the MOU, the only edit was made in our subcommittee when we last met to make the edits to the juvenile civil citation program and to make the edits to the MOU. And the AO was not touched because everyone, as stated by Judge Holmes, felt that, hey, we were waiting on what the chief judge was going to do regarding his edits to the administrative order. So the only edits that were made following that meeting was to the AO, and that was made by the chief judge as general counsel.
So does the chief judge's order clearly define the clerk's role?
Yes, and I can send that over. I can send that over to the collective group as well.
Okay. Is there maybe I'm just not clear? Is that are you saying this process that we're talking about where you ask for input, we submit, and we go back and forth. That's not where you were when you came to the meeting today. Was it not? That's not what you want to do? Were you not clear on the process?
I thought this is where when I left our meeting, this is what I thought. Because the AO was not touched by the subcommittee, and I know edits were made to the MOU and the Juvenile Civil Citation Program, I thought the committee wanted us to just work with the chief judge to finalize the administrative order, since it was an agreement between my office and the clerk's office. And then we finalize the administrative order, we sign our MOU, and we're going to send everything back, send everything over to Gordon with the finalized version of the administrative order, the finalized version of the MOU, and in our signed civil citation program with both my signature and the clerk's signature on that. So I thought the process was going to flow sent from Gordon to me. I sign off the civil citation program. I sign off on the MOU. We get the finalized version from the chief judge on the AO, and then we submit it to Mr. Weeks for his signature. So I guess I mixed it up with regards to the AO. It makes sense given the fact that the chief judge made edits to the AO, should have paused it there and then sent it to the group as a whole to look at the AO. But I was thinking, because the MOU only addresses what's going on between me and the clerk. So as you know, the memorandum of understanding, it's only between the state attorney's office and the clerk's office regarding my screening process, right? The public defender has nothing to do with the screening process. We're working on the process to where law enforcement officers would send those notice to appears to us, my office, rather than the clerk's office. So I thought the MOU was a separate issue in the sense that it's only a written agreement between my office and the clerk's office. So I thought we were the only entities dealing with the administrative order. So I'm fine with sending an administrative order for the collective group and us going through that and actually making the edits to that if anyone finds anything. But that was my thinking in that, because it was the only two entities that were dealing with that particular portion of the agreement. And we were the only ones that administrative order was really dealing with. The administrative order only addresses the state attorney's office and the clerk's office and our duties and our agreement for my screening process. So
and you're the elected state attorney. Yes, I got you. Judge Holmes.
Administrative orders become the law for the entire circuit. I made it very clear at the last meeting. I made it very clear at the subcommittee meeting when we were shown the MOU between the state attorney's office and the clerk. I told Mr. Pryor, I said it, and I'll repeat it. The NAACP takes no position with the memorandum of understanding that you have with the clerk. However, we want to see the administrative order, which affects the entire 17th Judicial Circuit, and we want to see the finished civil citation policy and procedure, because it incorporates by reference the administrative order. So we want to see what it looks like, because we're going to live with that. That becomes the law for the entire 17th Judicial Circuit. So your MOU, we made it very clear. The only thing I offered was, told you had surplus in there. You talked about a memorandum attachment, and I told you that, there was no attachment. Just to let you know, I did read what you sent me, but I don't care. The NAACP has no position with regard to your MOU with the clerk of court. We want to see the entire juvenile administrative order, because it has implications and ramifications down the road for the entire 17th Judicial Circuit. And I want to make sure that the chief judge covered everything, that deals with the civil citation program as relates to officers turning in probable cause affidavits, issuing civil citations, missed opportunities, things of that nature. So we've been foreclosed from even making suggestions and offering. When I was on the bench, Jack Tudor, whenever he was going to do an administrative order that dealt with something in criminal, he would circulate it and say, look, I'm about to do this. What do you think? Okay. And we had input. The judges get input. So I'm pretty sure he's going to ask Judge Williams, if he hasn't already. That would be my question. Judge Williams, have you seen the proposed juvenile administrative order?
Yes, I have. And part of the concern is that, and I don't want to get into sensitive legal stuff, but as I understand it, if this cannot be repeated as everywhere, because I operate under the radar. The concern is, Judge Holmes, is can an administrative order by a judge shift a duty, a statutory duty that a clerk has or perceives that they may have? So that's the salient legal question which lawyers are looking at. But again, that's not to be thrown about and thrown in anybody's face. So that's the only last question that, as I understand it, that's the hangup, is that if that administrative order will shift the statutory duty that the clerk has a right to say, hold on, I need more clarification. Again, this is a bigger issue than me, but I've given my input. So.
Well, the clerk of courts in Miami is doing it. So by agreement, that can be, because, it can be done. You're not foreclosing the clerk from doing a statutory duty. You're just asking her to postpone it until there can be a review to see if a statute has been violated. That would be 985.12. And that's how, why I looked at that administrative order, and I knew it had to be amended, but I'm not the elected state attorney. He wanted to do that.
Yeah. And guys, if I could just add something here. I have heard the term that Harold is the elected state attorney at least a half a dozen times, if not more, today. Let me just give you my thoughts on that. I was the sheriff's lawyer, and for 44 years, I watched Mike Satz convince this county that although I am the state attorney elected, I have no control, I have no influence, I have no ability to pressure any law enforcement agencies on anything. Mike and I fought. We went around in circles behind closed doors because I thought, like Kamala Harris, he was a chief law enforcement officer. Quote, he was a top cop by virtue of him being the state attorney. The point I'm making is 44 years, Mike Satz has convinced this community he has no control, no power, no influence. I pick up a newspaper and I read that he's the most powerful guy in Broward County, but Mike Satz had convinced himself and this county that he has no control, no influence, no ability to pressure anybody. So I think if Harold Pryor is going to turn that around, he's going to need more than just 4 months. It took 44 years to get us to this position. So I'm just giving you my 2 cents because I'm out there talking to these chiefs and stuff, and I have to resurrect their thinking. Mike has convinced them of this for 44 years. So understand, guys, we're trying to shift the whole that's been going on while we were still in middle school, a way of thinking. So I'm just giving you my 2 cents because I'm out there. It's very difficult to shift that thinking.
Well, Judge, once again, I have to disagree with you. Whenever I had a problem and I called Mike Satz and told him what was going on, it stopped immediately. And it maybe because it was me and I knew it to throw around and sling around a lot of statutes, and I still know how to do that. But he never told me that he had no power. And he changed policy in his office a lot of times because of me. And I can give you examples where he changed things because I called and complained to him. So I disagree with you on that. People have the power to do what they want to do. All right. And that's all I can say. If he wants to do it, it can be done. If he doesn't, then you take the position, oh, my hands are tied and I can't do it. But Mike Satz wielded a lot of power in this county. And I don't care what he said to people about what he couldn't do. I personally have experienced Mike Satz doing things that I've asked him to do, and it didn't take a long time for it to get done. So, if you want examples, I'll give it to you, but I don't think I have to, just to know that I know Mike Satz well enough to know when I called him personally, things got done.
Let me say this, Judge. I agree with Judge Holmes. Hang on, Judge Williams. I was at a forum, and I believe Johnny McCrae was the MC, and Johnny McCrae asked the question, who's the most, it was Scott Israel was there, who's the then sheriff, and Mike was on this panel, and the question was, who's the most powerful law enforcement guy, most powerful politician in Broward County? And Mike Satz stood up and said, I am. I've had many experiences, just as Judge Holmes did, when I remember even calling to talk to Mike Satz about civil citation. I said, we need to talk to all the chiefs. within 14 days, the chiefs were in his office. He was telling them, I can't make you do it, but there are other things that I can do to make sure that these things will get done. I don't know that person that you said he describes himself. He may have not said, I've never heard him say, I am the state attorney at at a meeting such as this or any meeting to remind us that he's the man. But he behaved in that way. The only time I've ever heard him say that is when he was asked that directly. We've asked many occasions for him to have to discuss an issue, to work on something, and those things that did. I understand Mr. Pryor is new, but I'm surprised that he's reminding us. And I know you heard that he's a elected state attorney. We're saying that because that's what he told us. And I'm sure he told us that for a reason. So we're saying, yes, we understand that. And we realize that's where why you're sharing that with us as well. That's being said because that's what was told to us. And I get it, but now I know we're not working. His office is doing what he's doing and not following the process. I didn't know that until today. But now that I know, we can carry on. But go ahead, Judge Williams.
Yeah, I just want to say this. I agree with Judge Holmes. If I picked up the phone and called Mike Satz could be in the middle of a murder trial, and less than 5 minutes later, you would take a recess and he'd be on my phone. That was the respect that he gave me, and so did Howard Finkelstein. What I am saying to you is that when I dealt with Mike Satz on issues involving agencies, for example, we're in federal court in front of Judge Hoover on overcrowding of prisoners. We needed Mike to deal with the overcrowding problem because he's prosecuting these cases. Mike's position, I can't tell these police agencies what to do in Broward County. We in federal court. We then go back down there dealing on the Miranda rights issue, in which you wanted to change the form for all the agencies to have one form that was simple for people to understand it. Mike Satz stands up and says, I can't tell these agencies what Miranda form to use. Okay, I kept seeing it time and time and time again. So yes, as an individual, he responds to anything I've ever asked him for. But when you're asking them to tell police agencies what to do, it's a whole different ballgame. I'm just telling you what I see from my personal experience.
Well, I personally experienced, you may have seen the memo of when the children were getting arrested for vaping, and they were mostly children out west, and they were being charged with felonies in many cases as the law required. It was the state attorney's office that issued a memo and said, stop arresting these children. We may not be able to test it properly. We don't want to ruin their lives. We want to see if you can charge them with something else. And then the arrest stopped. State attorney's office can do what it chooses. Now, if our state attorney chooses to do something else different than what he agreed to do, then that's fine. He just need to tell us that that's the way. So I'm just trying to figure out what he's doing. And if he doesn't agree with what we talked about anymore, just say that. That's all I'm saying. Just say what you're going to do and then just do that, whatever that is. And if you change your mind, just let us know. Because we are serious about where we are with these children. So, we just have to find out what our elected state attorney's office wants to do. And then we'll go from there. So everybody, I guess everybody has the fourth generation of the agreement and we don't have anything else. So I assume that the state attorney's office will send us the others if he so chooses. Also, we talked about the JAC regarding the missed opportunities. Once perhaps we can do this simultaneously while BSO is putting in a place. At some point, to Chief Evans, while they're working on that, we could revisit the MOU that was in place for the other agencies. I know you just had one or two on board. So if other agencies brought civil citation eligible children there, and since we will have in October cross-trained folk that can do that, can issue a civil citation, if that will then suffice for the process. So we're good on that, Chief Evans?
Yes, I'll add that back to my discussion with Tamika because they facilitate that process.
Okay, because I think there was a draft that Tamika sent out regarding that, those pieces there of children who were eligible as well. So that while BSO is sharpening their process and getting their staff in place, they can also, unless you see an issue with that, Colonel, if other agencies they sign an agreement allowing you all to place an eligible child to civil citation, that you would be okay with that.
Yes, we're going to be working with Ms. Evans and her crew to make sure that we're all on the same page. We'll see what the other agencies do. They're saying that they're going to come on board, but we'll see. But we're going to go ahead and set the bar high and make sure that we have our protocols in place.
Okay, so
with
that'll
no
be
exceptions.
the full policy there for your staff by October is what we're.
Yes, and that's with all those levels in place.
Okay.
And the reason why we have to wait until October is a collective bargaining issue within our Department of Detention, where they have to bid for posts, and one of the posts is going to be a cross-certified person there at the JAC who's eligible to write the civil citation.
Okay. Okay. Any questions?
Madam Chair.
Yes.
Madam Chair, if I may add, I know Mr. Walters was requesting that information. I have it right here in front of me. If I can read it real quick.
Yes, please.
In reference to demographics for May of the 31 arrests, we had 4 that were Black females. We have 21 Black males. We have 2 white females, and we have 4 white males for a total of 31 arrests.
Thank you.
Okay.
We have an issue, and I believe Judge Williams brought this concern of Baker Act some time ago of juveniles, the increased number of juveniles from the courts as well. And he said, I just don't understand what's going on. And so we realized that certainly statewide, and we're only dealing with Florida, there is an issue. And so I wanted to, we sent the information from the numerous reports and articles. And Judge Holmes, if you would do a review, please, on the Baker Act of children in Florida.
Yes. As a matter of fact, tomorrow night at 7, the NAACP is hosting a webinar in conjunction with the Southern Poverty Law Center in Palm Beach County. Well, actually, they're from South Florida area. But just to give you a synopsis, 37,000 children every year in this state are Baker Acted. The youngest on record has been, because no records have been kept really of who's been Baker Acted, but the youngest has been 5 years old. Oftentimes, these children were Baker Acted from their schools because there are 3 entities that can order a Baker Act. That's a judge, a medical professional, and a law enforcement officer. The standard is real low. They deem that the child is a danger to themselves or to others. They're kicking and screaming. They won't calm down. They can initiate the Baker Act process. A lot of parents were reporting their children missing. They thought they had run away from home or something, only to find out that their children had been Baker Acted. 72 hours in an institution, and they didn't know. So the Florida legislature passed what is known as Senate Bill 590. 590. It was passed both by the House and the Senate. And I'll give you the highlights of that bill. It was sent to the governor for his signature and is due to take effect on July 1st. It requires notification. And it also gives a definition of what it means to notify the parents. They need to document how many times they tried, who they called, how many times they tried to call. They have to do more than just say, well, I tried to call and nobody answered. They got to make every effort to find that parent before that child is actually admitted for Baker Act. It also requires documentation by DCF of the number of children who are going to be Baker Acted or have been Baker Acted. So that's a mandatory requirement under this statute. Also, it kind of helps out the civil citation program. If we ever get it off the ground, it adds the following requirement. It recommends to law enforcement that a student who commits a criminal offense be allowed to participate in a civil citation or similar pre-arrest diversion program as an alternative to expulsion or arrest. And it assigns a student who commits a petty act of misconduct to a school-based intervention program. That sounds, intervention, program, sounds like promise. If a student's assignment is based on a non-criminal offense, the student's participation in a school-based intervention program may not be entered into the Department of Juvenile Justice Information System Prevention Web. So if they're in school and they get in trouble, you can't enter it into the juvenile or the JIS system, so it doesn't get held against them. So Senate Bill 590, it helps a great deal. I have an alert on my computer to tell me if the governor signed it. So if he signs it, I'll get a pop-up to let me know that he signed it. Those are just the highlights, but tomorrow night, they're gonna go in depth. And I will tell you that the key factor to this Baker Act is the majority, 54%, at least 54% of the people who are Baker Acted are Black children, Black and brown children, but predominantly Black children. So this is something that, we got to address. It doesn't involve the state attorney's office. It just involves the police being trained better, and it involves, the reporting. If the school's going to call the police to have the child removed, they got to make every effort to find the child's parent. That's it in a nutshell, Madam Chair.
But just remember that parental notification is not the same thing as parental permission. So they will, call some folk and, that sort of thing. But oftentimes they will not, children won't, they don't need the parents' permission to do so. And I don't know, I guess it's always, and people say unintended consequences, I'm not so sure that is the case. It's always Black and brown children. When the children, and they're even in this circuit, when children are released, we've met families who from Jackson, they were not connected to any care. And so let's just say for the sake of argument, they had a legitimate reason. But when they released, they didn't tell the parent that, the school district has a yes team. It's kind of a team that deals with children who have issues and may have thinking or hurting themselves. They're not sharing any information at all to say do this or do this. Agency provides some aftercare, any of those things. And then you have the children who never should have been Baker Acted, a 5-year-old or 6-year-old, a lot of elementary students in the first place. But that seems to be their answer for us and our children too often. And so we have to address that as well. And as I said, I started thinking about it some time ago when the pre-COVID, when Judge Williams had a concern about the number of children that were being Baker Acted from his courtroom. We are, I guess the best news is we not the worst. That's Palm Beach County. But the bad news is we're not doing well in this issue of how we're treating our children when it comes to Baker Act, and the family has no authority once they've taken these kids away. And so I can share with you that we are working with Southern Poverty Law Center. I have sent out to many of you, and I'll resend out the reports that were done with the numbers and the issue. And it is a very sad report. It is a lot of work was done. And so we will be, our agency will be working with Southern Poverty Law Center, and that's who will present tomorrow, the findings. We will also be working with, and I'd like this committee to give some consideration to working with our state legislators, because even those that are leaving will still be around in order to file bills. We'd like to follow up. The bill as it passed was a shell of itself from what the original bill was asking for. But we may not get it was a step in the right direction, so they went what they have. It's oftentimes, they tell me, it's oftentimes to get something on the board first. So this is the one step that they took to try and get some reform to this 50-year-old bill. We'll be working with Attorney Bacardi Jackson, and I believe and another gentleman who's been assigned to us in this piece as we will go on. And we will also be working with Legal Defense Fund regarding that second piece that had to do with putting information, the children's information, into JJIS or giving it to the Sheriff's Department. You all may know that there is an issue in Pasco County where that sheriff he is the largest intelligence task force in the states, or in one of the largest in the country. And one of the duties of this is to get these children, and they may have run in the hallway or got into a fight or any of those things, and they share that information with the sheriff's department. The sheriff department inputs that data, and they decide that based on their knowledge in law enforcement that these children are going to be criminal. And the sheriff department in Pasco County was going to people's homes. And anytime they felt like it, said, "You need to show me your kid." And they would just hound these people, say that their kids are criminal. They would question them: "Where's your daddy? Is your daddy in prison? Is your mom addicted?" All these type of things. You all may know that Congressman Bobby Scott used to be NAACP president. We took the issue to him. He is calling for a congressional hearing on this issue. Department of Justice has been brought in. And I say all that to say, that reminds me of Broward County School District wanting to put promise data into JJIS. And so we, the NAACP, have filed a lawsuit against that district, that county. They said they're backing off, but people say one thing and do another. And we will also be moving in that direction for this Baker Act piece, hence Southern Poverty Law Center and LDF. We have got to do better about our children. And we all, I think everybody on here got a title, but unless you use that authority that you have to help anybody, it doesn't do us any good to have all these titles. But we've got to do better about our children in every category that we see. It's always the Black and the brown children who are getting mistreated the most in this issue. So I'm not clear where we over impotate ourselves, but this whole piece. But we've got to be serious about this. And so I can tell you that our organization is, and I hope that this board is, as we move forward, to make sure that we support our juveniles. And let me just, a lot of the children that have been Baker acted have diagnosed disabilities. So they're acting like their diagnosis says they're going to act. And yet we have one answer. There's all different types of sheriff's departments that are doing, law enforcement agencies that are doing different things. And we've got to make sure that we address those for our children across the board. On tomorrow, my counterparts of the other branches and college chapters will be taking information from parents whose children have been Baker acted in Broward and throughout the state of Florida. It is a state of Florida activity that we're doing. It's both an educational piece and also a action alert as well as to where we're going to go in helping our children. So we will do whatever we have to do regarding Baker Act, regarding civil citation, regarding this 12-year-old, whatever we got to do, we're going to do that. I do know that Aramis is running for, she's running obviously for a different office now, but she was able to do some really good things when she, as the first Florida's Black state attorney. So I will reach out to her again to see. I know we had a talk. Judge Holmes, I believe, is 19 when those two 6-year-olds were arrested, and she went on to move that did not happen, and she shared that with her replacement. So I will certainly be in contact with Aramis, because you can know that she really cared about children, not from what she said, but from what she did while she's in office. She made sure that her replacement also followed suit to care about children. Are there any questions about anything we've talked about thus far? Yes, Judge Williams.
I just want to say this. I litigated Baker Act issues 20 years ago, and I coined this term. A Baker Act is nothing more than a heart attack of the brain. A Baker Act is nothing more than a heart attack of the brain. The appellate courts like that language. Here's my argument. I still can't figure out, and I've been struggling with this question, how does it benefit anybody to say that a child is having a heart attack of the brain if that child is not having a heart attack of the brain? In other words, if you go to the emergency room and you tell that person, I got chest pains, I guarantee you they're going to take you in right away and you ain't going home for that night. So I'm struggling with what's the benefit of law enforcement agency issuing all of these Baker Acts? It's like I'm looking at the numbers right here. It's 2 or 3 times what they were years ago. It's like double and triple in some counties. I don't understand what's the benefit of saying someone's having a heart attack of the brain when they're not having a heart attack of the brain.
Well, apparently it's mostly black and blind children that's having a heart attack of the brain.
Okay.
If you want to believe that, it's always us, always our children. Okay. Okay. Any other?
Excuse me, Madam Chair.
Yes, Colonel, and
Yeah.
then Chief Evans. Yes.
Yeah, unfortunately, I have to go.
Yes, sir.
But I wanted to thank you for giving me the opportunity to go first. And just to let everyone on the advisory board and those looking in know that if you have any questions, you need any assistance, please don't hesitate to reach out to me. I believe in handling business when called upon, and we're working really hard to improve things and make things better here, starting at the top with the Broward County Sheriff's Office, and be the model for the rest of the county.
Thank you, Colonel. I appreciate
Thank you.
it. Take care.
Okay, bye.
Chief Evans, and then Colonel, Commissioner Holness.
Thank you, Madam Chair. Just wanted to know, Judge Williams, you picked up a paper. Can you, if you don't mind sharing out the reference that you're using, what article it was? I think, Madam Chair, you also mentioned a publication that recently came out, or perhaps Judge Holmes, if you could say the name of it.
Yes, mine is called More Florida Kids Are Being Baker Acted. It's the opinion page of the Miami Herald dated April 7th, 2021, Wednesday, April 7th. And just to be very quickly, Judge Leafman concluded that the reason why we've got so many Baker Acts of youths is that it coincides with the fact that we've had a dramatic reduction in arrest. So when a cop basically shows up to the house, for example, the house is all torn up in glass and broken, the parents are saying, arrest him. The cop will say, I'm not going to arrest you, but I got to do something with you. So they'll just go ahead and Baker Act them. So there's a correlation between the reduction in arrest dramatically in Florida and the fact that we're using Baker Act as an arrest tool. That's his theory.
All right, perfect. Thank you, sir.
Thank you. Okay. And I believe that it's called?
It's called Costly and Cruel.
Right.
It's the report by the Southern Poverty Law Center on the misuse of the Baker Act in Florida each year on our children. And also I have the Committee and Children and Families and Elder Affairs copy of Senate Bill 590. It's titled School Safety. So Ms. Evans, I'll get that to you. I can just forward the email from Madam Chair that she sent to me, and I'll send it to you. It's good reading.
Thank you. Commissioner Holness.
Thank you, Madam Chair. Let me first start by thanking Colonel Holmes' wife, Mrs. Holmes. Thank you for allowing him to be with us on your vacation. And thank you, Colonel Holmes, for being forthright and straight with us on the issue. I just wanted to give you a quick update that the resolution we discussed was passed by the County Commission on the 1st. Thanks for all of your input and support in putting this together, Judge Holmes and so many others. It's already been sent to all the cities. I believe the city manager and mayor. I'm going to push to get it to every elected city official in Broward County, make sure that they get it and see it and understand it. We're doing here to get the support we need to keep our kids on the right path, build prosperity for all of our future. I just wanted to give you that update, Madam President.
Thank you.
And everyone.
Thank you.
And I may have to get off to run to another meeting that starts at 5. So if I jump off, please forgive me.
Okay, well, you're in luck because we're going to finish up early today.
Oh, good.
Chief Evans, give us your numbers for the Juvenile Detention Center.
All right, absolutely. Good afternoon again to all. As of 12:58 this afternoon, the department had 29 youth in secure detention, 24 of those being male and 5 of those being female. As it relates to COVID numbers, as of June 8th, 2021 at 3 p.m., the department report for the Broward Detention Center for employee COVID numbers, 40 had tested positive, with 37 of those being cleared. And for the youth, 7 had tested positive, with 7 of those being medically removed from medical isolation. Based on some correspondence I received, the detention facility is under quarantine until June 14th of 2021. And so those are the numbers there. And just, Madam Chair, sometimes I mention this, but for the month of May, running from the 1st to the 31st, we had a total of 107 admissions through the Juvenile Assessment Center, resulting in various release options along the way. And so those are our numbers, and I can provide additional updates as it relates to the Juvenile Advisory Board and our upcoming site visits, if you would like.
Yes.
Okay, perfect. All right, so the as a request of the subcommittee on civil citation, we there was an ask for really looking at the facility, kind of understanding the flow of things, kind of seeing how we would like to see civil citation youth I guess, place at the facility. So again, we have 2 site visits scheduled for those subcommittee members, one taking place on June the 10th and one taking place on June the 17th. Both of those are Thursdays in the afternoon time to accommodate the schedules of our committee members. And the biannual, committee meeting, our committee JAC Advisory Board meeting is scheduled for June 29th at 1 o'clock. And Madam Chair, I know I included you on that invitation, and there's the rest of the other stakeholders who are there. So please feel free to share that invitation out with others for the JAC Advisory Board. As far as the site visit is concerned, because it is a secure facility, that I'm asking that, I know this is a public meeting, so folks are hearing it. So that the committee members have confirmed their attendance, and we're kind of scheduling that process. But touring the inside of a secure facility is a little bit different. So if someone else is interested in kind of learning more about that, then we're kind of getting back to post-pandemic in-person activities. And so after we meet for the June Advisory Board, if that's really a need or a request of the community, then I will work with Broward Sheriff's Office, Department of Detention, how we will facilitate additional tours. So that concludes my report, Madam Chair.
Did you have any information for us on missed opportunities?
I just had an opportunity. Yes, the May report was just provided to Tamika yesterday. She did an initial data review and had some questions and some recommendations. I do believe, and I will look, I want to say the number for the month of May, total number, not including our disqualifying offenses, was 13. So it was less than 20. I do know it was a smaller number. Many of those still are domestic violence cases that show up on that report. And so Tamika and I talked about how that data is presented in its totality without respect to our jurisdictions disqualifying offenses. And so the numbers are not a perfect match, but that was just yesterday when I returned back to the office.
Do we know how many of those were not domestic violence?
When I did the original, I want to say out of those that were presented, Tamika identified maybe 4 who were, based on the program criteria, would have been authentic missed opportunities, if my recollection is correct.
And the agencies, because I can bring her over.
Okay, let me see. We have, and I'm looking at my email, technically 15 youth were arrested. Oh, good, my memory held up. 15 youth were arrested. Technically, looking at our criteria, there were only 3 missed opportunities. And again, 1, we have a question about the age at the time of the offense. And as far as agencies, I do remember BSO was on the list, but the other ones she may be able to speak to, but I will have to pull that data to be accurate.
Tamika, do you have some additional information to add on the missed opportunities report?
Yes, there were 50, when we got the report, there were 15 listed, 11 were domestic violence. There are only really 3 missed opportunities, and they were from Davie PD, Coconut Creek, and Lauderhill. Those are the true missed opportunities. BSO was on the list. However, BSO was on the list for offenses that were domestic violence related. So it was Coconut Creek, Lauderhill, and Davie PD. And there's one that there has to be some, BJJ has to look into the data to see if there was a discrepancy, because it looks like that person wasn't eligible due to age.
Okay, do you know if the missed opportunities report was shared with the law enforcement agencies, the right people at those agencies? Like did Colonel Holmes receive the report? Because we had asked that he would review these cases to determine if they were indeed domestic violence.
Okay, so we just reviewed this report yesterday. The missed opportunity reports are being sent to every designated contact for the law enforcement agency. Colonel Holmes is included as a part of BSO, as well as every chief. They're receiving them monthly.
Can you share with us who, and you can do this via email, who at Coconut Creek and who in Lauderhill got the emails? Because when we contact them, I don't want Chief Stanley and the other one to say that we didn't get it, which is what they always say.
Absolutely, I can share. And how do you want me to do it, via email?
If you know it, you could say it now, or if it's not the chief, is it to get assigned to somebody? You know, who at the agency? I remember we had this issue with who's no longer the general, who's immediate past chief in Hallandale, sorry, Miramar, and he said it was going to his secretary. He never got anything, and so we were able to determine that he actually was getting it. He just wasn't checking that email address. So I want to know who is it.
Yeah, if you give me a moment, I'll pull that up for you.
All right, thank you, ma'am. All right, and while she's doing this, we did not get the information from Colonel Holmes, but we will we'll make sure we take care of that. Anything else for the good of the order? Anything else you need to be concerned about? We will work with Judge will work with spoke to Representative DeBose on yesterday, and he will work with us on any of the juvenile bills that did not pass or need to be improved upon. I know that there was the one on that spoke to arrest of children, and I spoke to Representative Williams, and she called me near the end of session, and she was extremely upset because they had rolled the juvenile justice bill into one and took their names off it, the sponsor's name off it, and put someone else from the other side of the aisle's name on it, and did what they did because they could do it. But we need to make sure that we put on the record the changes we're seeking in those juvenile justice bill to include the Baker Act one. And the sooner the better, because they will go into, I think it's in September is when they go into committee meeting to move into the next step. So even though there are several and Broward won't be in office at the time, they do have a strategy. They can still file and then work through someone else who will be there to sponsor it. And I think Ms. Knowles could give us those dates as we go along when they need to, committees meet, when they need to file their bills, and how they need to structure it. Is sometime in September, is it not, Ms. Knowles?
The first committee week, good afternoon, everyone. The first committee week is September 20th through September 24th.
Thank you. So we would need to get with our delegation prior to that in order to get on board there. Okay. Thank you, Ms. Knowles. Ms. Evans, do you have something else?
Yes, my apologies, Madam Chair. I just wanted to also let the advisory board know that we have been continuously meeting since the earlier part of this year as it relates to the failure to appear rate, the outcomes of the detention risk assessment tool, and why we bring children into care and custody to be securely detained for I don't want to say technical offense, but for a court process. And so the committee has been diligent. I want to thank Yolanda Brown publicly for the work that she's done to help us unravel what has become a very complex system. I want to thank Judge Williams for stepping us through the logic model that he used, and we've used it within our framework of discussion. And the committee met, and out of the work we're doing, we've because the stakeholders are present, we are looking at, we've kind of reassembled ourselves for the JDAI effort, Juvenile Detention Alternatives Initiative, because the stakeholders are there. And so we're using the principles of JDAI and moving forward. One of the things that had taken place since the last time we met, and even presentation to this board, was the loss of Judge Frank Orlando. And we know the role that he played in nationally and of course locally. And so we said Broward County being the inaugural flagship site for JDAI in the country, we thought it would be prudent and certainly a great way to honor his legacy in that work by kind of reassembling and doing the work under the umbrella of JDAI. And we were just doing bits and pieces of it, so we really just galvanized that energy again. So I just wanted to report to the advisory board that on the third Fridays in the afternoon time, I convinced John James to be there and late in the afternoon on Fridays. And we worked real hard on unpackaging some of the issues as it relates to juvenile detentions and the alternatives that are available within our community or not, and were still needed. So just wanted to let you know that's happening.
Thank you very much. Yeah, his loss will be, it's great. It resonates with all of us. All right, Ms. Gaynor, are we ready?
Yes, I'm here. It's going to the chief. I was actually looking for the first name of another person that's associated with the chief, a C. Brown. It went to that person. So it's going to the chief and that person. I don't have the first name. That's what I'm looking for.
That's in Lauderhill?
No, that's in Coconut Creek.
See somebody named Brown and the chief.
That's correct.
And what about Lauderhill?
Lauderhill is going to the chief. It's going to a Sherry Bynes, and there's a L. Williams.
Okay. Alrighty.
I can email you the names. I just don't have them in front of me. I only have the email addresses.
Thank you, ma'am. I appreciate that. Okay. Anything else for the good of the order? All hearts and minds are clear.
Move to adjourn.
Meeting is adjourned. Thank you, everybody. I appreciate it.
Yeah.